I move that leave be granted to introduce the following bill standing in my name, shortly entitled Computer Misuse and Cybercrime Amendment Bill 2024.
I second, Madam Speaker.
Honourable members, it has been moved and seconded that leave to introduce a bill shortly entitled Computer Misuse and Cybercrime Amendment Bill 2024 be granted. Those in favour?
Aye.
Those against? The ayes have it. I call upon the Premier.
Madam Speaker, I introduce the bill standing in my name, shortly entitled Computer Misuse and Cybercrime Amendment Bill 2024. I will explain its provision at the second reading. Madam Speaker, I move that the bill shortly entitled Computer Misuse and Cybercrime Amendment Bill 2024 be read a fourth time.
I second, Madam Speaker.
Honourable members, it has been moved and seconded that the bill shortly entitled Computer Misuse and Cybercrime Amendment Bill 2024 be now read a first time. Those in favour?
Aye.
Those against? The ayes have it. I call upon the clerk to read the bill for the first time.
This bill shall be cited as the Computer Misuse and Cybercrime Amendment Bill 2024.
Thank you. I call upon the Premier.
Thank you, Madam Speaker. Madam Speaker, I move that standing order number 52-2 be suspended to allow for the bill shortly entitled Computer Misuse and Cybercrime Amendment Bill 2024 to be read a second time.
Madam Speaker, to raise my concerns with this 1 to 3 approach on bills that have significant implications on the fundamental rights and freedoms of the people of the Virgin Islands. Madam Speaker, this bill, with the implications that it has, should have been out for greater public consultation. For example, Madam Speaker, within this bill, the police can ask persons who are of interest in criminal matters to provide them with the password to their phones. And there are other things within this bill that are very troubling, that must be ventilated for the understanding of the public. What we are doing in this House is wrong. I wanted to make sure that I raise my concerns on that. The Premier should not be doing this without public consultation.
Is there a second to the Premier's motion?
Madam Speaker, I second.
Honourable members, it has been moved and seconded that standing order number 52-2 be suspended to allow the bill entitled Computer Misuse and Cybercrime Amendment Bill 2024 to be read a second time. Those in favour?
Aye.
Those against? The ayes have it. The motion is passed. I call upon the Premier.
Thank you, Madam Speaker. Madam Speaker, I move that the bill shortly entitled Computer Misuse and Cybercrime Amendment Bill 2024 be read a second time, and I will now give the objects and reasons. Madam Speaker, I rise today to address a crucial matter concerning the Computer Misuse and Cybercrime Act of 2014 and its implications for our jurisdiction in light of recent findings from the Caribbean Financial Action Task Force. This discourse is central to our legal framework and holds significant importance for our standing in the international community. The Computer Misuse and Cybercrime Act, enacted in 2014 and amended in 2019, establishes essential provisions aimed at safeguarding computer materials from unauthorized access, modification, and interference, while addressing the broader challenges posed by cybercrime. However, there are numerous gaps within this act, which has caused severe limitations on the investigatory powers of law enforcement, which in turn has undermined several predicate offense matters that were before the court. As we continually strive to bolster the security and integrity of our information systems, it is imperative that we examine and amend this legislation to align with international standards. In February 2024, the Caribbean Financial Action Task Force released its fourth round mutual evaluation report, which assessed the Virgin Islands' compliance with international standards. The report classifies our jurisdiction as compliant with 11 recommendations, compliant with 11 recommendations, largely compliant with 25 recommendations, partially compliant with 3 recommendations, and non-compliant with 1 recommendation. This comprehensive evaluation highlights areas of achievement as well as those requiring urgent attention to strengthen our anti-money laundering and combating the financing of terrorism framework. Immediate outcome 7 of the MER reveals that amendments to the Computer Misuse and Cybercrime Act are vital to the enhancement of our current investigative and prosecutorial tools. As we draw nearer to the close of the observation period, it is imperative that we demonstrate meaningful and measurable progress on the recommended actions to avoid the jurisdiction being placed on the grey list for a protracted length of time. As it stands, the Act is limiting the scope of investigations, thus allowing criminals to take advantage of the system. The proposed amendments aim to rectify deficiencies by realigning our legal framework with international standards, improving law enforcement's effectiveness in investigating and prosecuting serious crimes, all the while striving to safeguard the individual rights. Particularly, they seek to introduce clearer definitions, broaden the scope of applicable offenses, and strengthen investigative powers for our law enforcement agencies. Without these amendments, the law enforcement agencies would not be effective in investigating and prosecuting cybercrimes and more broadly financial crimes. Furthermore, amendments will give access to necessary information during investigations and provide for the lawful seizure of computers, ensuring that evidence obtained remains admissible in court. In order to secure MLTF convictions, there must be sufficient evidence to dispel the evidential burden, and so these amendments to the Computer Misuse and Cybercrime Act would allow for modern technology such as computers and phones to be inspected for and admitted as evidence. Thus, these proposed changes are not merely legal formalities. They represent our commitment to strengthening our AML, CFT, CPF framework and to provide the international standards set out in the MER regarding law enforcement and improving our investigative procedures. By implementing the recommended actions outlined in the Caribbean Financial Action Task Force Mutual Evaluation Report, the Virgin Islands would be operative in promoting global security and preventing the abuse of our financial systems for illicit activities. In conclusion, Madam Speaker, by fortifying our legal framework, enhancing coordination among domestic and international agencies, and augmenting the capabilities of our law enforcement agencies, we are taking cogent steps to prevent and combat cybercrime and financial offenses. Together, let us demonstrate our unwavering commitment to transparency, accountability, and a secure financial landscape for these Virgin Islands. Thank you, Madam Speaker.
Is there a second?